In the spring of 2025, the Supreme Court issued a unanimous ruling, all 9 justices. The order was clear. The Trump administration had to take steps to bring back a man it had wrongly deported to El Salvador. The administration looked at that ruling, and then it didn't bring him back. Not through open defiance, not by saying the court was wrong, but through a single word. The ruling said the administration must facilitate his return. The administration said facilitating meant asking El Salvador nicely. El Salvador said no, and that, the administration argued, was that. The man stayed in prison. The court's ruling stayed on paper. Here's the question this raises. Can a president actually do that? Can the most powerful office in the world look at a Supreme Court decision, even a unanimous one, and find a way around it? And here's the deeper question. Is what Trump did in 2025 something new? Or is it part of a much older story about how presidential power actually works in America? Today, we're going to trace exactly where the court's authority ends and presidential power begins. We'll look at the tools any president can use to slow walk, soften, or quietly sidestep a ruling. We'll look at what Trump has done specifically. And we'll look at what it means for who holds the final word in American government, not just now, but going forward. Because right now, that question is not theoretical. Let's start with something most people assume they know. The Supreme Court is the law. Once it rules, the president enforces it. That's how the system works. That's the textbook version. The real version is more complicated. The court has no army. It has no budget. It cannot arrest anyone, freeze any funds, or stop any policy on its own. A Supreme Court ruling is, in the most literal sense, a document. What gives that document its power is one thing, the expectation that the president will carry it out. Take away that expectation, and the balance shifts. This is not a new problem. In 1832, President Andrew Jackson was confronted with a Supreme Court ruling that protected Cherokee land in Georgia. The ruling was clear. Jackson's response, at least in spirit, was just as clear. The court had spoken, and Jackson was going to do whatever he wanted anyway. The Cherokee were forcibly removed. The trail of tears followed. The ruling meant nothing because the one person responsible for enforcing it chose not to. That moment revealed something the textbook skips. Enforcement is a choice, and the person who makes that choice is always the president. The headline is never just the ruling. The real question is always, what happens the morning after? So what does a president actually do when he disagrees with a court? There are 3 moves. They are not secret. They have been used by administrations of both parties, but they are being used right now in ways that are worth understanding clearly. The first move is reinterpretation. A court ruling applies to specific facts in a specific case. When the Trump administration was told to facilitate a man's return from El Salvador, it reinterpreted the word facilitate to mean something close to nothing. This is not unique to Trump. Every administration has lawyers whose job is to find the narrowest possible reading of any order that limits what the executive can do. The administration complies technically while keeping the policy intact underneath. The second move is delay. Court orders do not execute themselves. There are appeals to file, stays to request, procedural steps that take months. During that time, the original policy continues. In early 2025, federal courts ordered the Trump administration to halt certain deportation flights. The administration appealed, sought emergency pauses, and in at least one case continued transfers while the legal process ran. A federal judge found probable cause of willful noncompliance. The case reached the Supreme Court, which ruled on narrow procedural grounds, not on whether the administration had actually defied the order. The compliance question was never fully resolved. The deportations had already happened. The third move is substitution. When a court strikes down a specific policy, the executive branch rebuilds it under a different legal justification. In early 2025, the Supreme Court ruled that Trump's sweeping tariffs exceeded his authority under the emergency powers law he had cited. Within hours, the administration announced the same tariffs under a different statute. Same policy. New legal wrapper. The challenge resets. The clock starts over. Each of these moves is individually defensible. Together, they add up to something the ruling did not intend. Here's where the story gets more interesting. The court itself has been changing the rules of engagement, sometimes in ways that make it harder to stop executive action, and sometimes in ways that give courts more leverage. In June 2025, the Supreme Court significantly curtailed one of the main tools lower courts had used to check presidential power quickly. For years, federal judges could issue what are called nationwide injunctions, orders blocking an administration's policy from taking effect for anyone in the country. Not just the people directly involved in the lawsuit. These orders had been used repeatedly to freeze Trump's executive orders within days of them being signed. The court ruled that judges no longer have that authority. A court can protect the specific people before it, but it cannot freeze a policy for the entire country. What this means in practice is that while a legal challenge works its way through the system, sometimes for years, the policy stays in effect for everyone else. By the time a final ruling comes down, the administration may have already done what the courts were trying to stop. At the same time, a 2024 Supreme Court ruling gave Trump and every future president significantly broader protection from criminal liability for official actions. This doesn't directly change how civil court orders work, but it signals something about where the court sees the boundaries of presidential power. They are wide and getting wider. These are not partisan decisions. Several were written by justices appointed by both parties. What they reflect is a court that is actively redrawing the map of how much any president can do before the judiciary can effectively intervene. And Trump is operating on that new map in real time. Trump did not invent this pattern. Roosevelt pressured the court by threatening to pack it. Nixon delayed and argued until he had no choice left. Eisenhower calculated compliance like a political transaction. Each of them pushed. Each of them stopped short. What makes Trump different is not the tools. It is the pace and the consistency. These moves are happening across multiple policy areas. At the same time, immigration, trade, civil rights enforcement, with no sign of slowing down. The relationship between a president and the court has never been a clean line of command. It is a negotiation. It runs on political cost, public attention, and the expectation that both sides will respect the outcome even when they disagree. Trump is stress testing how much that expectation can hold. So what is the limit? Is there a point where the court can actually force compliance? The honest answer is, it depends. A lower federal court can hold administration officials in contempt, meaning it can find that they willfully violated an order and impose consequences. That process is slow. It requires evidence. It can be appealed at every step, and it has never been used successfully against a sitting administration that was determined to fight it. The Supreme Court itself has almost no direct enforcement mechanism. It has used its contempt authority against a private party exactly once in its entire history. It has never used it against a sitting president or a cabinet official. There is no mechanism, no precedent, and no clear path. What the court has instead is legitimacy, the weight of public expectation, the political cost of being seen as the administration that openly broke the rules. That cost has historically been enough to keep presidents in line, not because the court can force them, but because the political fallout of outright defiance is worse than the cost of compliance. But political cost is not a fixed number. It depends on how much attention the public is paying, on how the administration frames its actions, on whether we are complying with the spirit of the ruling lands as credible or not. That argument doesn't have to be legally airtight to work politically. It just has to be believable enough that a constitutional crisis never quite arrives. What does this mean going forward? The tools Trump is using will be available to every future president. The precedents being set now on reinterpretation, on delay, on substitution do not expire when this administration ends. They become part of the landscape that the next administration inherits. A Democratic president facing a conservative Supreme Court will have access to these same moves. A Republican president in a future administration will have them. These are not Trump's tools. They are now presidential tools. The question is how far they can be pushed before the system pushes back. Congress can respond in theory. It can pass clearer laws that leave less room for reinterpretation. It can use its budget authority to pressure compliance. In extreme cases, it can move toward impeachment. In practice, all of these require a level of political agreement that is very hard to assemble in a divided government. Congress has not moved decisively to constrain executive action in any of the cases we've discussed. States can sue, and they have, but state lawsuits operate through the same court system, the one that just lost some of its ability to issue immediate nationwide stops on executive policy. If this pattern holds, the balance of power between the presidency and the courts could look meaningfully different within a few election cycles, not because of one dramatic confrontation, but because each individual move, each reinterpretation, each delay, each policy rebuilt under a new legal label quietly pushes the boundary of what a president can do before the court can effectively say no. Let's come back to where we started. A unanimous Supreme Court ruled that the Trump administration had to take steps to bring back a wrongly deported man. The administration said it was complying. The man remained in a foreign prison. Can a president do that? Based on everything we've looked at, yes, within limits that are real but often unclear, through moves that are individually defensible, over timelines that stretch long enough for the practical outcome to be decided before the legal one. The Supreme Court's authority rests on the assumption that the president will carry out its decisions. When that assumption becomes conditional, when compliance is a calculation rather than an obligation, the question of who holds the final word in American government becomes genuinely open. Trump did not invent this problem, but he is pushing it further than most presidents have. This may not dominate the headlines for long. These stories are complicated. They move slowly. They don't have a single moment where everything breaks. But what is being decided right now through each reinterpretation, each delay, each legal workaround is where presidential power actually ends. And by the time that question is fully answered, the answer will already be in place.